Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled Texas Appeal Court Ruling. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, I need you all to hit that like button. And if you're new to my channel, hit that subscribe button. And also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, guys, let's get to it. Okay, so as you all remember, I did the video titled Child Support, Texas Attorney General Concession on Appeals. If you all haven't watched that video, when this video go off, then simply click the link in the description box to watch this video titled Texas Attorney General Concession on Appeals, okay? In that video, I simply went over the Attorney General's response to my Ox Appeals brief, okay? So, yesterday he received the order, so we're going to go over that order in its entirety so you all can see what has taken place in the case thus far. So, without further ado, let's get to the order. Alright, so now, as you all can see on the screen, this is in fact the order that Ma'ak received from the Court of Appeals. And it reads, vacate and dismiss an opinion filed April 11th, 2023. Then it states, the state of Texas with the seal at the top. Then it states, in the Court of Appeals, 5th District of Texas at Dallas. The appeals court case number I crossed out. Then it reads, in the interest of the child with the initials, I crossed out. Then it reads, on appeal from the 256th Judicial District Court, Dallas County, Texas, with the trial court cause number, I crossed out. Then it reads, memorandum opinion. Then it states, before Chief Justice blank, Justice blank the third, and Justice blank, opinion by Chief Justice blank, right? Then it reads, the trial court signed a default judgment in the underlying lawsuit on November 12, 2020. So now you all can see back on November 12, 2020, the trial court entered a default judgment against Ma'ak, right? Now let's read the next sentence. Appellant, who was Ma'ak, filed a motion seeking to vacate the default judgment in March 2022, okay? Then it says that was denied following a hearing before an associate judge. So that's basically being stated that we motioned to vacate that default judgment that was entered on November 12, 2020, back on March 2022, which was denied by the associate judge, okay? Then it reads, following a de novo hearing, the trial court signed an order adopting the associate judge's order on October 26, 2022, right? So after we had a de novo hearing, the trial court judge adopted the associate judge's ruling on October 26, 2022, right? Okay, cool. Let's continue. Appellant, who was Ma'ak, appeals from this order because it appeared the trial court lacked plenary power when it signed the appealed order. We question our jurisdiction over this appeal and direct the appellant, who is Ma'ak, to file a letter brief addressing the jurisdictional issues. Then it states, judicial actions taken after the expiration of the court's plenary power is a nullity, and any orders signed outside the trial court's plenary power jurisdiction are, now let's go to the next page, void, with case law to support that. Then it reads, we have no jurisdiction to consider the merits of an appeal from a void order. Case law to support that. Then it states, when a party appeals a void order, we must declare the order void and dismiss the appeal for want of jurisdiction. Case law to support that, guys. Then it states, because appellant did not file a motion for a new trial or motion to modify within 30 days of the signing of the default judgment, the trial court's plenary power over the judgment expired on December the 12th, 2020. Then it states, see Texas Rules of Civil Procedures 329BA, and it reads, motion for new trial due within 30 days after judgment is signed. Then it states 329BD, trial court retains plenary powers over judgments for 30 days after judgment is signed. Then it reads, consequently, the associate judges and the appeal order of the trial court were signed after the trial court preliminary power expired. Although appellant filed a letter brief, he addressed the merits of the appeal instead of the jurisdictional issues. Our jurisdiction over an order signed after the expiration of the trial court's plenary powers. Then it states, for reasons stated above, the appeal order is void. Right? So again, by reading that, it states what? For reasons stated above, the appeal order is void. So the orders of the associate judge and the order adopting the associate judge order is void. To further prove that, let's read it. It states, accordingly, we vacate the trial court's October 26, 2022 order and dismiss the appeal for want of jurisdiction. Exactly what is stated above. So because the trial court's order was outside of the court's plenary powers to even enter that order, that made that order void. So we moved to vacate that order when we filed an appeal. The appeal court judge agreed that that order was void because it's outside the court's plenary powers. So we won that. We got that case vacated. And because it was outside the court's plenary powers, it's also outside the Court of Appeals jurisdiction. So the Court of Appeals jurisdiction couldn't hear the rest of the appeal because of the simple fact of the matter is the order that we are appealing is a void order because it was done outside of the court's plenary powers. So now let's go to the judgment also signed by the courts. So let's go there. Okay, so now as you all can see at the top of the screen is in fact the seal of Texas, and it reads Court of Appeals, 5th District of Texas at Dallas, and this is in fact the judgment, and it reads, in the interest of, again, the minor child initials I crossed out, the appeals court case number I crossed out. Right hand side it states, on appeal from the 256th Judicial District Court, Dallas County, Texas, trial court cause number I crossed out. Opinion delivered by Chief Justice blank, and blank participating. Then it reads, in accordance with this court's opinion of this date, we vacate the trial court's October 26, 2022 order and dismiss the appeal for want of jurisdiction. We order appellees, the state of Texas, and blank recover their cause of this appeal from appellant. Then it states judgment entered on the blank day of April the 2023. So again, guys, we got the initial order from October the 26th, 2022 vacated. We needed to get that order vacated, guys, so now we can challenge the December the 12th, 2020 default order, okay? So basically when we moved to vacate the 2020 default order, we did it outside of the court's preliminary powers. So because we did it outside the court's preliminary powers, the trial court could not enter an order, granting or denying what we filed. But not only did they deny the motion, they also added more to the order. So we had to get all that vacated. Because we didn't get that vacated by the appeals court, then that order would stand and we cannot challenge the initial default order that we was challenging initially, okay? So now people can say, well, how can you continue to challenge the default order if it's outside of the 30 days the court had preliminary powers? So this when the next step comes in. So our next step, guys, is to do what? Is to file this thing called a bill of review. So let's go there. I just want to show you all more. Let's go there. Okay, so again, the question is, why must we file a bill of review now? So now let's pick this up at Texas Rules of Civil Procedures 329B, the same Rules of Civil Procedures that was quoted inside of the appeals court's memorandum. Now let's go to F, right? F, and it reads, on expiration of the time within which the trial court has plenary power, a judgment cannot be set aside by the trial court except by bill of review for sufficient cause, filed within the time allowed by law, provided that the court may at any time correct a clerical error in the record of a judgment and render judgment non pro tunc under Rule 316, and may also sign an order declaring a previous judgment or order to be void because signed after the clerk's plenary power had expired. So again, guys, that's why we're doing the bill of review, because the court's plenary power was expired on December 12, 2020. So let's see how long we have before we can file a bill of review. Let's see if we missed the time or if we still in the time frame. Okay, so now as you all can see, we're coming from Western Legal, and it reads, a bill of review is a way to attack a judgment and try to get it vacated. A bill of review typically must be filed within 4 years of the date of the judgment. So again, guys, we have 4 years from the date of the judgment. The judgment was done December the 12th, 2020. We're only on April 11th, 2023, so we still have plenty of time. So after we received the order yesterday, I draft my ARC bill of review up, and he filed it into the courts today. That's how fast we're moving, okay? But we couldn't do the bill of review until we got the prior orders vacated in the appeals court. which we have done. You see? So I tell you guys, this is a fight. You have to be willing to fight the good fight. You got to be willing to go through each and every step in this timely matter, because everything is done in a time frame. But let's continue, guys. Then it states, if you have a recent judgment within the last 2 to 4 weeks, then you should seek to file a motion for new trial. If the judgment is older, then a bill of review may be an option. You have 4 years to file a bill of review. You technically could file it after 4 years, but you will have to prove some type of stringent fraud. This is a very difficult task. Then it states, why file? Usually a bill of review is filed because the consumer was never served with the lawsuit. So remember, guys, if you go back and now watch the other link that I put in the email, that the attorney on behalf of the agency basically stated out of his mouth that there was improper service and there's no evidence of my ARC even being served. So a bill of review is perfect for that type of argument. So my ARC will win and get the whole case vacated. I'm letting you guys know that now. So after we win that, he will come on and give his testimony. But let's continue. It states, if you recently discovered a judgment against you from years ago, then a bill of review would be considered. Typically, you need sufficient proof that you were not served. For instance, maybe you were not living at the residence that the plaintiff claims you were served at. Obtaining affidavits from others prove this will help your case. So now we don't need an affidavit from others to prove this to help our case. We have the attorney who did a concession on appeals admitted to that simple fact. So again, guys, the case is already over. We just following the process to get it completely vacated. But again, I just wanted to show you all that we are winning appeals cases and we are winning in lower courts. We are doing it all over here, guys. There is no other channel on the internet showing you guys this type of information. Live cases going on as we speak to this day. I'm providing more evidence, more facts, more proof, more truth. If you all need my help, hit me up in my email at yahuah@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. Oh yeah, guys, but before I check out, let's also go to the Texas code so you all can see that the Texas code states the same thing. Without further ado, let's go there. See, we're coming from Texas Rules of Civil Procedures, and subsection 051. Then it reads, every action for which there is no express limitation period, except as an action for recovery of real property, must be brought not later than 4 years after the date the cause of action occurs. So again, guys, that's all I'm going to do for today. If you all need my help, hit me up in my email again at yahuah@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. Let's continue to apply that pressure. And with that being said, guys, you all be blessed. All glory and honor to the Most High Yah. And with that being said, I say shalom.